Well, good afternoon and welcome everybody to the Wednesday Lunchtime Drive-Thru on this Wednesday, June the 23rd. I am your host, as always, Damon King. I'm a certified financial planner professional and wealth management specialist with ChappelWood Financial Services. I'm also the lead instructor for ChappelWood University, which is our educational branch. And as we always like to do, we like to bring you new and interesting topics. And throughout the summer, I especially like to have some friends. I do have friends, even though I don't get out much, Mitch. I do have a few friends, and I'm proud to call Mitch Janik one of those. So Mitch is our special guest today. Here's a little bit about Mitch. He is an attorney. He's an estate planning attorney specifically with the firm Cain and Cain. They're based out of Norman, Oklahoma. For those of you who are outside of Oklahoma, and we have several of you, that is just south of the Oklahoma City metro area. Mitch has more than a decade of estate planning experience, both in terms of an attorney, but even before that, while he was going through law school, he worked in law firms on the administrative side and the assistant side. Currently, he develops and oversees the Estate Settlement and Trust Administration Department. That sounds really, really complicated, Mitch. I'm sure you're going to tell us all about that. He also helps to manage funding, trust funding for the firm. He's a member of the National Network of Estate Planning Attorneys. And the thing that I like most about Mitch is that he is a true educator. He's a teacher. He believes, like I do, that it's not enough that you know what is going on with your estate plan. He wants you to know why it's happening. So Mitch, welcome to the Wednesday Lunchtime Drive-Thru.
Well, thank you very much, Damon. We really appreciate that. And you're absolutely correct. Myself and the other attorneys at our firm really do love to teach this topic and this subject. So we're happy to sit in on your lunch drive-through. So I appreciate the invitation.
Well, you're very welcome. And you know, sometimes, Mitch, it's a little iffy when we're talking about estate planning. You know, of all of the retirement or financial planning areas that we discuss with our clients, and on our radio show and on our new television show, people are okay with investments. They don't like taxes, but they want to find out how to save on taxes. Insurance is a necessary evil. You know, we know about Medicare and healthcare, but estate planning. Nobody likes talking about the topic that reminds them that they're going to die someday. And so we find that people put that off. And so it's important that we talk about it. And it goes far beyond just what's going to happen with your stuff. It's about the legacy that you're going to leave. And so I have a few questions that I want to ask you. But before we get into that, ladies and gentlemen, as a reminder, this is your time. This is for you. Mitch is here for you. He's not here for me. So if you have a question, please use the Q&A function to ask any question about estate planning that you want. You can use the Q&A function. You can use the chat function to kind of get the ball rolling. Mitch, I've got a quick question here for you. What are some of the key estate planning issues that you are currently discussing with your clients there at Cain and Cain?
That's a great question. You know, the most current things I'll point out are right now there is some legislation being proposed both in the U.S. House and the U.S. Senate that is looking to significantly change a lot of the estate planning tools that our advanced planning clients utilize in order to avoid estate tax after they pass away, save on that, different strategies of gifting strategies to beneficiaries. And there's a whole myriad of tools, specialized tools that are used when you get into the advanced planning, higher net worth clients. And so it's been really interesting because Congress has always been looking at ways that they could potentially attack those. And now with the current administration and the current seating of both the House and the Senate, they have gotten as far as proposing legislation that would eliminate and or change many of those tools. Now, it's funny whenever we talk about this, of course, the first question our clients have is, oh my gosh, you know, but how realistic is this going to happen? Well, if you've listened to the news in the last umpteen months, you can tell that right now there's a lot of gridlock going on. And so we never know what's going to happen in Congress. I certainly try not to, as an attorney, predict what Congress is going to do. But it is interesting that we've gotten to the point where they actually have legislation that is proposed. It may or may not go anywhere, but it could. You never know.
Yeah.
And even if it doesn't, the current estate planning and gift and estate tax laws are set to expire in 2025 and revert back to much lower numbers.
Yeah. So right now, a person could pass away, and I know that it's indexed for inflation period, but let's say you could pass away with about $11 million right now and leave to your family or charities and still not have to pay any estate tax, correct?
Correct.
Okay.
And that would be per person.
Correct. So in a married couple, they can unify theirs together, and whoever the surviving spouse is, if there's any remainder left over from the deceased spouse, they can add that to theirs and potentially have an estate valued at $22 million or less and still avoid estate taxes.
Correct. And so
how is that changing, though, as you just mentioned?
Well, and so what they're proposing, and there's a couple different variations. So the Senate has Bernie Sanders, Senator Sanders has presented his version of the bill. The House has their version. They're proposing lowering that to $3.5 million.
Wow, per person.
Yeah, per person.
So from 11 million to 3.5. Wow. Okay.
Yeah, and in the House, they are wanting to, what's called decoupling. They want to decouple the unified credit. So we'll step back for a second, and there's this little more advanced concept that every U.S. citizen has. We like to call it a really highly technical thing, a coupon. Everybody has a coupon in their lifetime of whatever the federal exemption is. As you said, it's about $11 million per person. Well, right now, that includes lifetime gifts in addition to whatever's left when you pass away.
So gifts in life and in death are unified together right now to equal
Correct.
That. Okay.
And what the House version of the bill is proposing is to pull away and separate out lifetime gifts as a separate item and lowering the coupon to $1 million.
Wow.
So
wow.
you can see, right, and so what ends up happening is right now we've been having discussions with our clients who are if they're on a borderline or getting close to that taxable amount, we know right now we could utilize gifting strategies up to $22 million. But if some variation of these bills pass and they do actually decouple the gifting from the estate tax threshold, that could seriously diminish some capabilities of what you could do during a lifetime to avoid some of those.
Yeah, and this is really concerning, Mitch, for certainly all of our clients, because we are working with millionaires and aspiring millionaires. The vast majority of our clients have estates that are valued well above $1 million. So ladies and gentlemen, when we're talking about your estate, that's different than just your investable assets. What you have in stocks, bonds, mutual funds, insurance contracts, rental properties, whatever. That's part of your estate. But also included in the value of your estate is the value of your residence that you live in, the value of any life insurance policies, the face value that you might own. Artwork, cars, anything that has value, correct, Mitch, is part of your taxable estate.
You're absolutely correct. And it is as broad of a net as you can conceive. It's pretty much everything and anything that you have your name on or that you have possession of gets included in your gross estate calculation after you pass away. And so that is something to consider. It's one of the things we are often teaching our clients and the general public about is we always kind of joke, we're all worth more dead than alive. usually, but that's kind of how the numbers pan out, is when you start adding up all of the values, particularly life insurance. People don't really think about life insurance. Well, the death benefit that gets added to your gross estate.
Yeah, and what's interesting is that death benefit is going to be received by the beneficiaries generally tax-free. But for purposes of the deceased person's estate, their estate could still pay taxes if it goes above those limits.
Exactly. So that's been a pretty big item that we're watching. That is the hottest topic in estate planning right now.
Yeah.
But it's one of those. Generally, we know there's a couple different proposed versions. Most likely, if they were to proceed forward, most likely they're going to get negotiated down or negotiated into some other form. However, the fact that they've gotten it to this point and actually have proposed legislation is further than either House or the Senate have gotten in a long time. So it certainly raised our attention.
Yeah. Well, another kind of an estate planning rule that we take advantage of is the step-up rule. When you're transferring property after death to your heirs, and it helps to minimize potential capital gains taxes. What do you see happening with that? Is that still on the chopping block?
It is. That is part of the House bill. They are looking at eliminating this concept of a cost basis step up and also getting rid of the carryover. So let me back up for a second and talk about what is cost basis and why is it relevant in estate planning. So generally, whenever let's say you purchase some stock, right? So you purchase 1,000 shares of stock at, we'll say $1,000 a share. So you've got, 1,000 shares, $1,000. That is your cost basis for tax purposes.
So what is that? That's $1 million basically.
$1 million. So $1 million worth of stock. If you turned around, in a couple of years and you sold that stock and it was worth, $1,025 or $1,050, we'll say something a little more aggressive. You only get taxed on the portion of growth, not the initial investment. The initial investment is what the IRS considers is your cost basis. And then that growth is only taxed against the capital gains tax rates. And there's some other variations, that long-term, short-term, things like that. But generally, that's the concept. Now, if you, quite often when we see estates, sometimes parents will reach a certain point that they start gifting assets to their kids. Well, if a parent were to gift, let's say, this stock to their children would receive the same cost basis that mom or dad paid for it. So then if the child turned around umpteen years later and sold it for a profit, one would hope, they would then get the same cost basis that mom and dad had. Now, if mom and dad left that stock as a bequest through a will or a trust to the kids, so they inherit it, there's a different calculation, and that is called the cost basis step up. And so what ends up happening is the beneficiaries or the children would inherit that stock at the date of death value, fair market value of that stock. So back to that example, let's say the stock was worth $1,025. The beneficiary children would receive a cost basis of $1,025. So then if they turn around and sell it, they realize little to zero capital gains and pay very little to no taxes on it.
So without that step-up rule, then if they inherited the $1 million cost basis, and now it's worth $1.25 million, now you got $250,000 worth of growth potential.
Exactly.
And you're going to pay taxes on that. But now if they inherited at the market value, now their starting point is the 1.25. And if they turned around and sold it quickly with no appreciation, they would have virtually no tax.
Exactly. And the same thing applies to land, which but pretty much anything except for retirement plans, park retirement plans to the side. Those are animal. But For most part, this is a big impact if some variation goes through. Now, there's some practical application of why this cost basis step up exists. Because when you get into really old stock, for example, let's say your parents started a company and they each, started with 50% of the shares in this company. They started it 50 years ago. They built it up. Trying to figure out what their cost basis is in that stock would be very difficult, if not impossible.
Right.
So for a practical matter, it just makes sense to say, you know what, it doesn't matter what the original owners paid for it. Let's just get the date of death value and call that the beneficiary's cost basis. It's just mechanically a lot easier for the IRS to deal with.
Yeah.
We'll see what happens, but that has been proposed. They're also proposing, the House's version is proposing to also get rid of even that carryover cost basis. So
yeah.
We'll see what happens with that.
A lot of stuff going on. So obviously estate planning, good, solid estate planning is very important. As I like to tell people, you have an estate plan whether you know it or not. The only question is it one you created for yourself, or is it one that you've allowed the state to create for you? And so, I like to have control over my money. I'm sure everybody else does here too. So can you share a recent client story? You don't have to give names or anything, but just an example of where some solid estate planning has really saved one of your client families a lot of time and money.
Absolutely. Piggybacking on our discussion about cost basis, that was a situation. I had a situation last couple of years where it was a privately owned bank, and through the process, they had done estate planning, solid estate planning. We had things in place. We were able to help the successors, the family, get things done privately, so they didn't have to go through the public probate process.
Right.
And ultimately coach them on getting the documentation necessary and the valuations necessary to have the family business bank stock adjusted under having the cost basis adjusted, and it ended up saving all of the shareholders in the company millions of dollars because they had their cost basis adjusted up, and none of them were even aware that was an issue, or that they were the ones who had the burden as the taxpayers to establish that and paper that up. And that's the other little gotchas. You don't know what you don't know, and going through the process, that can end up costing you a lot of money down the road if you don't document as the taxpayer what that date of death value cost basis would be.
And so is this true of any, so I know for a fact, we've got some people on the call today that they own a business interest with family members. All right. So their family owns part of it. They are an investor with their family. And so is this a strategy that could be beneficial? Are these issues that really can plague any business interest?
Most business interests, definitely the decedent's shares of, say for a corporation, if it was an S corporation,
Okay.
S corporation, that would definitely get a step up in the cost basis of the underlying stock shares. For a more LLCs, your little less formal LLC business, there's an interesting thing you can do with LLCs and partnerships, which has to do with upon the death of any member, adjusting the cost basis on all the underlying assets. So that becomes very helpful in, let's say you've got an LLC that's a holding company for rental properties.
Which is a pretty common thing among our clients.
There you go. And so, if it's a mom and pop LLC holding company managing multiple rental properties, upon the death of the first spouse or one family member, that is an opportunity under the IRS code. You can adjust or get the date of death value of all the underlying assets of the LLC, thereby increasing the cost basis for everybody's shares across the LLC.
Yeah. And when you help clients with this, and ladies and gentlemen, let me stress that when Mitch and I talk about stuff like this, we're not saying you need to go out and do it. You really need to do, look, you can do it yourself investing all day long. Okay. But when it comes to this kind of stuff, you need a qualified, licensed attorney to help you out. And Mitch, I'm assuming that you don't just do this within a bubble. I mean, you work with CPAs, you work with clients' financial advisors to make sure that everybody's on the same page, right?
Absolutely. In fact, we find that probably the most effective estate plans is really when the family has a team of counseling-oriented advisors, attorney, but good financial advisor, CPA, having everybody at the table who knows what's going on, can contribute their expertise to it, to really support the survivors and the family, to really helps things to go smoothly and to optimize catching things of cost savings, all sorts of really simplifying and smoothing out the estate issues.
Right.
So it does take a team. It really does.
Yep. Ladies and gentlemen, again, if you've got a question for Mitch, now's your time. We still have about 10 minutes left. So if you've got an estate planning question, something very specific or even more general in nature, please put it in the Q&A section down below, or you can enter it in the chat. I will see it, and I will make sure that we ask it of Mitch. We don't have any questions right now. So Mitch, I'm going to ask you one more. And this is a question. The others were more high-level philosophical questions. This is a very specific one that I get a lot. And that is there an advantage to naming your estate as the beneficiary rather than your kids, or vice versa?
Great question. We get this quite often as well. This is, well, let's see, the short answer, of course, is going to be it depends.
Right. We use that answer. I thought that was just an answer Victoria and I gave all the time.
I say, no, it really does depend. Yeah. But generally, particularly when you're talking about things that have either beneficiary designations or life insurance or retirement accounts, when you reference the estate, just to get terminology down, that generally means through a probate. As your estate is what goes through probate versus naming someone or your trust or whatever your estate plan is. So the big advantage there is by naming, if you've got an estate plan or if if you're just naming your beneficiaries, that would at least avoid having to go through the court process, the publicity of the court process, the cost, the delay. And I will tell you right now, post-COVID, the courts are backlogged.
No, I can only imagine.
Backlogged. Yeah, the local courts had to be shut down for a short period of time during COVID. And so now everybody's just getting in line to do their probates. So it's been a little bit slow. There's that advantage on that aspect. Then you get into the other issues of naming, how do you want the beneficiaries to receive? And we often talk about this. It's one thing to just get assets to the next generation. But let's take it a step further and say, how would you want your beneficiaries to inherit? What I mean by that is kind of the general way most people leave their inheritance to their children is just, write in their name, leave it in their name, and they get a check.
Yeah, they'll leave them $50,000 or $100,000.
And what do? They take that check, they go down to their joint bank account with their spouse, they deposit that check, and now whose money is it?
Right.
It's now your child and their spouse, your in-law. So there's a risk there that, divorce rates being as they are, it's over 50%, upwards towards 60% for younger beneficiaries, younger people, generally, there is a risk that the beneficiary's inheritance, half of it could go away with the ex-spouse.
Yeah. And I would say as equally as concerning as divorce is a remarriage. And, if you've got children from a previous marriage, the new spouse may not be nearly as concerned about their non-biological children getting assets as they are their own. And you've got to take steps to not accidentally disinherit your flesh and blood.
You're right. And we hear these stories and we hear those concerns many a times when clients come to talk to us about how do we make sure our grandkids get the family farm or whatever the estate is. And so through good planning, you can make sure and protect that those assets are going to go to who you want them to go to. And then, like I said, expanding at, what about protections? What about putting some protections around that inheritance?
Right.
Against divorce, against the beneficiary's creditors, things like that. There's ways of doing that. And so
is it easier to do that through trusts or through wills?
Trusts really are the better way of doing that. Wills are a pretty simple tool. They can get complex, but at a certain point they become ineffectual to do the level of complexity that you can do with trust planning. So generally, that's modern estate planning is based mostly around trust planning with some other supplemental tools supporting it.
Yeah. So, Mitch, we've got some people on here who probably, either they don't have their estate plan or they need it updated a little bit. How do they, now we do have a question. I want to give precedence to the questions. All right. So here's a question from one of our great clients, Mary, and she asks, do you have any advice for an owner of an inherited farmland and minerals other than having them in a revocable living trust? The land was evaluated at the time of the last parent's death, but not the mineral rights.
So a lot of times we see with inherited farmland, minerals, some of the thoughts to consider is, how many beneficiaries? Is it just Mary? Are you the only one inheriting this? Do you have siblings who are also maybe participating in that or have an equal share in it? That is a question. Same with minerals. There are some strategies. Sometimes it makes sense to maybe form an LLC to hold the farm in the minerals, particularly if there's multiple beneficiaries. We see quite often we'll have a local beneficiary who lives near or on the farmland, and then other siblings who live out of state. And so the out of state beneficiaries, they just want their share, but they don't really want to participate or be involved in it. So there are different mechanisms using holding LLCs, things like that.
Okay. And so the question, I thank you, Mary, for that question. And Mary is like a lot of our clients who own land and the mineral rights to that land. And so if someone's got a question and they really want to visit with somebody, maybe they've never visited with anybody before, how do they go about getting a hold of you at Cain and Cain there, Mitch?
Well, they can generally call us and schedule a time to sit down and discuss their issue and their questions. And of course, as always, we don't charge for the initial meeting. We're just trying to see if we can help people out and answer their questions and see what issues they may have and what things they may need help with. And so they can always contact us at our main office. The phone number is area code 405-364-2246. They can also find us on our website, which is www.cainandcainlaw.com. CAINANDCAINLAW.com. Boy, we've got to come up with a shorter name than that.
Hey, you do what you can. So, hey, I'll come back to that real quick because I don't want to run out of time. We did get another question from another Mary. Mary asks, I have a trust with listed beneficiaries. If my brother is the beneficiary, how do I make sure that his inherited funds will always go to his children and not his new wife and her children? This is the exact issue that I was just talking about a moment ago. How would that be shown in the trust to make sure her biological kin get their fair share and not children who are not even related to her?
And this would be a counseling and drafting issue. So as how her trust was designed, how I would approach it would be to have limiting language in the trust, which essentially would have whatever's left in her brother's trust upon his death would then go to his heirs. And so just a little definitional note, in the state of Oklahoma, spouses are not heirs specifically. So that has to be somebody named, but the brother's wife would not be a default heir. It would go down to, or descendant, it would go to his descendants down to the kid. So that's a drafting issue, and that's something you'd want to make sure is written in the trust like that.
Yeah, and she says that she's actually in the state of California. So
okay.
There may, I don't know if there are any differences between Oklahoma and California law.
That's still, they may define it a little bit, but it's going to be a drafting issue. And so you want to make sure that it meets state law as a definition. And it can certainly be narrowed that way. That's usually part of the counseling and sculpting out of the inheritances. And so that is definitely something for her to have reviewed and looked at.
Right.
What it's doing.
Yeah, which is, again, why I stated, ladies and gentlemen, you absolutely need to have a qualified, experienced, licensed attorney who is reviewing these things for you so that you don't make a mistake. And related to Mary's question, and a lot of people get this confused, if you have retirement assets, life insurance policies, anything that has a named beneficiary, whoever is named as the beneficiary on those accounts will supersede anything you have in your will or your trust. So just because someone is named in your estate plan does not necessarily mean that that's who will get the money. If you have a life insurance policy and it names your ex-spouse that you hate their guts as the beneficiary, guess who's getting the money? Your ex. Okay, so in addition to updating your estate plan, anytime there's a death, a birth, a divorce, a remarriage, make sure you take the time to update your beneficiary designations, because that's another way you could inadvertently disinherit somebody.
That's a great point, Damon. If I can just piggyback on that, because that is one of the things we preach to our clients, is that it is critically important, particularly when it comes to estate planning at death, how things are titled, whose name is on the registered account owner, the beneficiary designation held with the company, how the company has the beneficiary designation is what controls. So you want to make sure that you have documentation that aligns with your estate plan, whatever your estate plan is.
Right. Yeah, and Mary made the comment here. She said that's actually one of her issues. Most of my money is in my IRA or 401k, and I was always advised not to name the trust as the beneficiary, but to give it to an individual. And there are times when a trust can be the ideal place to be the beneficiary. There are other times when it's better to just name a living person, right? And
that is true. And if I've got a few seconds, I will just, a few newer issues that have come through the courts in the last few years. There was a Supreme Court case that in the last 6 years, that essentially determined that beneficiaries who are not your spouse, who inherit your IRA or retirement account of any sort, do not receive the same creditor protections that you would have over your own IRA. So your IRA is exempt from your creditors in bankruptcy. If your spouse inherits it, most likely it is also protected from creditors. Your kids, it is not protected from their creditors' lawsuits and divorces. So that's a situation where it might make sense to have it payable to, say, a child's inherited trust share that has protections around it. There
Or
may
perhaps you don't want a $500,000 lump sum to be dumped on somebody. Not number one, you're going to have a lot of taxes because we're talking about tax deferred money here. But I will say this, with a trust does allow you to exert more control over your assets, even from beyond the grave, particularly in terms of, do you want your family to have a lump sum, or do you want them to just have income at certain triggers? And once they get to an age that you believe they're more mature to handle it, then you can dump all that money on them. That's another thing we see.
absolutely. And I know we're kind of running out of time here, so I'll make this.
We are.
Just, and that's one of the other things is, and you can do a lot of different methods in between there. So it can be a really protect the beneficiary from themselves, all the way to give them options. You may not see the risks that they're going to see at the time they're inheriting that money. And so giving them options is one of the big items we always counsel our clients on.
Well, that's perfect and a great way to end. And one of your best options, ladies and gentlemen, is to get some help with your estate plan, okay? And we counsel our clients on their estate plan, but we are not licensed attorneys. That is why we reach out to professionals like Mitch. So if you're needing some help, great call to make would be to Cain and Cain down in Norman, Oklahoma. If you don't have an attorney or you just want a second opinion, it does not hurt. You just heard Mitch say they do not charge for an initial consultation. And there may be some landmines that Mitch and his team down there, and Marty and Tamara and everybody associated with Cain and Cain can help you find that. And they may even just say, hey, this is great. You don't need to make any changes. Sometimes it's just helpful to have validation. So, Mitch, I want to thank you so much for being on our drive-through today. Really appreciate your time and for sharing all of this great stuff that's going on in the world of estate planning.
Thank you very much, Damon. Appreciate it.
You're welcome. And just one final thing before you log off. Don't log off yet. You got to check out our new television show. If you haven't caught it, we've had 2 episodes so far. It's all about the money, honey, which is a 30-minute version of our radio show that we have. It's going to air on Sundays at 11 o'clock, just after Joel Osteen on KWTV News 9 here in the Oklahoma City area. If you don't catch the episode live, you can always watch it on demand. Go to YouTube and check out the Financial Diva channel, and you can subscribe to our channel. And you can also subscribe to our playlist. It's all about the money, honey. And we upload the previous weekend's episode every week. If you have any questions you'd like us to feature on the show in a future episode, email it to me at damon@chappelwood.com. And I promise you, it'll show up on the show. I mean, we got a lot of airtime we got to fill, so it'll show up. So again, thank you, Mitch, for your time today. I want to thank all of you for being on the Wednesday Lunchtime Drive-Thru. Stay safe, take care, and we'll see you again next week on the Wednesday Lunchtime Drive-Thru. Have a great day. Bye-bye.